parallel sort of lawsuits. You're representing the Covington Catholic Kids. You've explained it before, but why did you want to keep them anonymous again in the pleadings?
So two reasons. One, they wanted to stay anonymous, and because they'd already had enough fame for a lifetime, didn't want any more of it. And so their goal was to stay anonymous from the inception. And the question was, could they stay anonymous in a way that and still bring suit and seek remedy? And my view was that so first it was their priority was to stay anonymous. But the reason why I wanted to pursue the case even so was because I thought they should be entitled to do so. My view is, in order to prove invasion of privacy, you should not have to forfeit that privacy as part of seeking remedy. And in particular, in the doxing context, you should not have to dox yourself in order to bring a claim against someone for doxing. And so here, while they had been doxed, they had not been doxed to the entire world. They had been doxed to about 10% of the world, probably 80% of their local community, but even there, not to everyone. And the more they could protect their privacy, which is what they're seeking in the suit is to do, the better. So to me, it made sense. I wanted to establish as a precedent that you could seek to protect your privacy without waiving your privacy in the process.
Okay, very interesting. Now, I'm going to read these super chats, but we're going to get to them in due course. Do you think the court will side with Barnes and his clients? Obviously, Robert, you're going to make your own prediction because I think it's a legitimate question. How can opposing counsel get away with saying the kids were harassing the native elders when the video shows different? They're not being honest. They're representing their client's interests, but we'll get there as well. To keep Robert in cigars. Even the defending attorney said that immunity needs to be delineated by the court, which is a main point of the plaintiff jury trial. Explain, and we're going to get to that as well, because that's the amazing thing. Okay, so thank you all, by the way, for the super chats. So you kept the plaintiffs anonymous. You sued, and we've done streams on this. We've talked about it. Warren and Holland moved to dismiss. They moved to move the case to federal court. It was moved to federal court. Federal court says, okay, now we're dismissing it on the basis of sovereign immunity. I was a little confused about this for a while. Can you explain the two provisions or the two legal statutes? You have the Westfall Act and you have the federal. Finish my sentence because I forgot it now.
Federal Tort Claims Act. So essentially what you have is the Federal Tort Claims Act is a waiver of sovereign immunity for particular kinds of claims. And you have to bring it pursuant to you have to exhaust your administrative remedies. You have to bring it in a certain procedural manner. You have to bring it in a particular court. And it's only a waiver of sovereign immunity for certain kinds of claims. So in particular, there is no exception. There is no waiver of sovereign immunity for libel or defamation under the Federal Tort Claims Act. So the Westfall Act was written in response to the U.S. Supreme Court case known as Westfall, who was one of the parties. And what happened was the U.S. Supreme Court said, you know what? Immunity is really limited to certain categories of actions and activities. So they changed how immunity worked based on whether you had discretionary authority or not for doing what you did. Congress did not like that. So that's why they passed an amendment to the law that said, no, we're going to overturn the Westfall decision and make it clear you have full immunity, regardless of whether it's a discretionary duty or a ministerial duty that you're up to. The U.S. Supreme Court subsequently interpreted the Westfall Act to simply codify what the immunity law was prior to its Westfall decision. However, whether they intended to or not, there's some people that would have a darker view of Congress. It was very quickly interpreted, the Westfall Act, was to expand immunity to people that did not have it before at all. Because traditionally, I know there were a lot of people commenting on the video talking about parliamentary privilege. The Speech and Immunities Clause of the U.S. Constitution essentially enshrines within the Constitution the protections of parliamentary privilege, and similarly limits it so that you cannot be sued for libel or defamation for anything you say in the halls of the Senate or Congress or the House, but you are completely unprotected for things you say outside of the Senate or the House under the Speech and Immunities Clause. Well, all of a sudden with the Westfall Act, even though nothing in the legislative history said anything about this, And no politician said, by the way, I'm giving myself immunity. Now, please reelect me. That did not happen. About a year or so after the Westfall Act was passed, Operation Rescue, a anti-abortion group, pro-life group, depending on where you are in the political spectrum, how you label them, sued Senator Kennedy for making statements that they called defamatory at a fundraiser in Boston. Now, the judges who would preside over that case, Kennedy was the first one to say, you know what, the Westfall Act actually expanded immunity, so now it applies to things outside of the halls of the Senate or the House. And as long as it has any kind of relationship to my job or duty, I have official immunity. And since there's no waiver under the Federal Tort Claims Act of sovereign immunity for a libel or defamation claim, neither I nor the United States can be sued. I should go back briefly. The Federal Tort Claims Act allows you to substitute the United States for the person you're suing. And the United States agrees that it waives its sovereign immunity for certain kinds of claims if the employee was acting within the scope of their duty. The Westfall Act just defined what was their duty or not, and that it could be a non-discretionary duty for which they're immune, as well as a discretionary duty. That's the way the two acts work together.
Okay, so the Federal Tort, we'll call it the Federal Tort Act, just because I miss the third word every time, it included waivers, but it did not include a waiver for liability. A waiver for defamation, sorry.
Exactly.
Which means not including the waiver for defamation means you could sue for defamation under the Federal Tort Act.
No, you can't. In other words, if somebody's acting within the scope of their duty, so here's how the Westfall Act and the Federal Tort Claims Act sort of work together. What happens is if you are suing someone that's an employee of the United States, and you believe what they did was within the scope of their duties, then what you're supposed to do is you're supposed to sue the United States. If you fail to do that, the United States can then intervene in the case through the Attorney General's office and say, actually, this individual, this individual should be removed from the case and it should be renamed the United States because this is actually a case against us because the employee was acting within the scope of their duty. But then what happens next depends on whether there's a waiver of sovereign immunity. So stage one is they say this was actually within the scope of their duty. So under the combination of the Westfall Act and the Federal Tort Claims Act, we're going to intervene and replace them. And so if you've sued in state court, they remand it to federal court and they tell the federal judge, we've certified, the Attorney General files a certification. We've certified this person was acting as an employee. And so we want to substitute in the United States for that party. So Operation Rescue goes from Operation Rescue versus Kennedy to Operation Rescue versus the United States. Then you get to a second analysis, which is what's the outcome. So if the Federal Tort Claims Act provides for a waiver of immunity for the claim that you brought against that employee, then you move forward against the United States in the suit. If they haven't, then the United States moves to dismiss on sovereign immunity grounds.
Okay, good. Now I hope that's clear for everyone. That's sort of much more clear for me. And incidentally, so do we know why the United States did not move to substitute for Warren or Holland in this case?
My view is it's because they did not believe either Senator Warren or Congresswoman Haaland was acting within their official duty, and that the Attorney General was not going to certify that. Now, the interesting thing about that process is that there are actually three ways to have that happen. One, you as a plaintiff can say that the United States should intervene and certify that they are defending the case. The United States can do so. The United States can move, the Attorney General can certify and move to intervene, or the defendant can request that the federal district court order the Attorney General to certify if, in fact, certification is appropriate. What was unique here is we did not sue either Warren or Haaland in their official capacity. They individually removed the case, but never sought certification from the Attorney General. And then they did not ask the judge to request the Attorney General to intervene. And the only logical conclusion to me is that they believe that the Attorney General would reject their certification request, that the Attorney General would say, no, this was not done within the scope of their duties as employees. And I'm sure particularly Attorney General Barr was not going in the Covington case. He was going to say Senator Warren was acting as her official obligations as a senator when she defamed a bunch of kids. I don't think he had any inclination to do that. I think they knew that because otherwise it made no sense for them not to pursue it or at least try it. The only reason not to try it was to put on record that the Attorney General rejected a certification request. I could not force the Attorney General to reject it myself, but they could have. But they must have been worried that that was a high probability for them not to do it.
Very interesting. All right. And Joshua Cornelius says, I had a real problem with the constant characterization of the harassment of the tribal elder. How is this a factual argument, and how likely is the court to be swayed by that kind of rhetoric? Well, okay, we're going to get there, Joshua, and thank you very much for the question in the super chat. Okay, so that's I think that's much clearer now. So they successfully had the case dismissed on the basis of the sovereign immunity, and you appealed the decision. Now, a lot of stuff was said in there that I'm not sure I totally understood the nuances of, where there was the statements, the reference to the Kennedy lawsuit. Do you want to elaborate on that and explain in detail what the application of that case is to this one?
So how all of this evolved is that the speech and immunity clause cases, particularly in the 1970s, the U.S. Supreme Court made clear that only statements that could have led the king to invade the parliament were the kind of statements that they were trying to protect, and that those are statements made either on the floor or had a close correlation to pending or proposed legislation. And they made clear that nothing else applied. Nothing else was really within the legislative duties or tasks. And they made that first in the Gravel case, and then after that in the Hutchison v. Proxmire case, 1972 and 1978. Then comes the Westfall Act, in which nobody's talking about this somehow changing the law of immunity. And as the U.S. Supreme Court would rule in 1995, they would say, all the Westfall Act did was restore the immunity that previously existed. Well, despite that, a few courts, I think only 4 courts in the country, have issued published decisions about whether the Westfall Act expanded immunity beyond the speech and immunity clause for defamation and libel claims. And it was convenient for the Congress that the first case involved Ted Kennedy. So Ted Kennedy made his statements at a fundraiser in Boston. Operation Rescue brought suit in Boston. I would have recommended they not do that, but that ship has sailed. That was 30 years ago. For example, to give people an idea, the First Circuit Court of Appeals also sits in Boston. There's not a single judge in that entire circuit or district that did not get his approval from Senator Kennedy before he got on the bench. So even if the Republican had appointed them, they had to get pre-approved by Kennedy to be there. So you're asking a bunch of people who owe their power to that senator to say he can now be sued. It wasn't going to happen. But the fortunate thing is the courts, and what they focused on in those cases really wasn't the arguments I'm making. They focused on the first argument Operation Rescue made was, hold on a second, nobody thought the Westfall Act applied to members of Congress. They were shocked by the suggestion. They didn't understand the political dynamic fully they were in, but or they wouldn't have brought suit where they did. So that was the argument, was whether or not Congress was included within the Westfall Act. Under its plain language, they were. Under the legislative history, there's nothing that talks about this. But I never thought that argument was going to be very strong. But that's what ends up being litigated. And what the district court says in that case is it says, look, Kennedy was responding to a press inquiry about pending public policy of a hot button issue. And so even if what he said was false about Operation Rescue, it's in the context of his duties as a senator. And what they're really saying is if he was not a senator, this question is never asked and he's not discussing it. He's discussing it because he's a senator. The press member who's asking him the questions is asking it on behalf of his Massachusetts constituents. It's a local Boston media network. And so now, while I view politics as what motivated that decision more than anything, their legal basis was the district court used some language that I knew I could utilize, because it went out of his way to say these were not gratuitous statements. These were not statements that came out of nowhere. These were not statements that were for personal motivations. These were for public policy because of his position as a senator. That's the first case to decide whether the Westfall Act expands liability. Then there are about 3 subsequent cases, 2 of them within the D.C. circuit. One goes up to the circuit, one decided at the district level, and then one in, I believe, Texas, maybe Oklahoma, that goes up to the 5th Circuit. And all of them expand immunity a little bit more. So Congressman Murtha is sued for statements he makes at a press conference about an ongoing investigation concerning a private citizen. That private citizen sues. Congressman Murtha says, hey, this is about an investigation that I'm the chairman of the committee and I was answering a press inquiry, and it's right within the Operation Rescue Doctrine. Murtha was a very popular congressman in D.C. He sued in D.C. Not surprisingly, they expand immunity and say, oh, it applies to him too. Then later on, another congressman is sued by CARE, which is a Islamic Relations Council for American Islamic Relations. And this one I thought was a ridiculous decision by the courts. It didn't serve my purpose to argue that in front of the 6th Circuit. But what they did is the congressman attacks CARE. He does so in the context of answering a question about his divorce, but he's saying because CARE somehow was connected to his wife's neighbor or something. And so he just goes on this long libelous thing about CARE. So CARE, of course, sues. And he says, golly gee, I same thing. I just like Congressman Murtha, just like Senator Kennedy. That was part of my duties. I had to libel those poor people. The D.C. Circuit decided, that makes sense, and expanded the immunity to cover them. None of the people in any of those cases made the argument that I made in Warren. Always the best argument was there have to be limits here. And if not, you've just given election to Congress a license to libel. And that was something no judge was going to feel comfortable with. But astoundingly, in the 30 years since the Westfall Act was passed, I am the very first person to make that argument to any federal court. There was a 5th Circuit case of a comparable, was like the D.C. case, and they went along. The 6th Circuit has never addressed it. No judge within the 6th Circuit has. And to give people a background, when I first brought this suit, a lawyer went on Tucker Carlson, and there are lawyers all across the board telling me all the people I could not sue and so forth. And she went on even Tucker Carlson and said, she didn't refer to me as Barnes. She says, that lawyer. God bless her. And so she said, oh, you can't sue Congress, period. There's no chance you can sue Congress. The reason why these cases have not been litigated is because all the lawyers quit before the fight began. I've never known anyone to win a fight who did not go into the ring in the first place. And so I looked at the law and I knew the legal background for it. And I knew that to a certain degree on paper, it was uphill. It was uphill because all the lawyers were saying you can't sue a member of Congress. But public policy wise, that did not make sense. Constitutionally, that did not make sense. And practically speaking, if I was a judge, I would not want it to be limitless. And so that's where the great utility here is. I told people, look, there's one of 3 outcomes I can get. Either they say, you know what, Congress is completely immune. If that's the case, I have a great argument to change the law to go. I already have congressmen lined up considering it, saying this is insane. Look at the Covington case. The court said that you're completely immune just because you're elected to Congress. And some smart member of Congress will run against Congress. It's always a smart way to do it. And actually, there's a good one who may be doing it himself, which is Congressman Thomas Massey from Covington, Kentucky. His primary opponent happens to be the Nicholas Sandman lawyer. I'll say nothing more. And so he might introduce the legislation to remove this in case the 6th Circuit says, oh, there's complete immunity here. Option 2 is what actually happened at the appellate argument stage, which is I got the other side for the first time ever, because those lawyers are representing Congress technically, even though they're representing the individual defendants, they've been hired by Congress, to admit on the record that there have to be limits. That's the first time they've ever said that. It's what the big prominent D.C. lawyer on Tucker Carlson said, there were no limits, and any lawyer is nuts who thinks there is. Well, I already got them to concede their limits. So now the only question is, do the limits benefit me in this case or not? Even if I don't win for my client, the clients get a big outcome that they want, which is establish that there's at least some sort of limit. And then we're only debating where the limits apply, no more that it's limitless. Or third, I get the courts to come in and say, you know what? Barnes is right. No court has ever said that this applies in this kind of context. We don't like this kind of context, so we're going to impose the limits ourselves, and the limits are going to protect his client. But in my view, I couldn't lose here. One way or the other, I was going to change the law by bringing the case.